Okay, so I'm not sure where that cut off, so I'm just going to play all of 10:55 again. And now instead of hearing the shower in the background, you're just going to hear driving noises.
1055. Placement. I. For purposes of Section 1052 of this part, the court may place the child in the custody of a relative or other suitable person pursuant to this article, or of the local commissioner of social services or of such other officer, board or department as may be authorized to receive children as public charges, or a duly authorized association, agency, society or in an institution suitable for the placement of a child. The court may also place a child who it finds to be a sexually exploited child as defined in Subdivision 1 of Section 447 of the Social Services Law with the local commissioner of social services for placement in an available long-term safe house. The court may also place the child in the custody of the local commissioner of social services and may direct such commissioner to have the child reside with a relative or other suitable person who has indicated a desire to become a foster parent for the child, and further direct such commissioner, pursuant to regulations of the Office of Children and Family Services, to commence an investigation of the home of such relative or other suitable person within 24 hours and thereafter expedite approval or certification of such relative or other suitable person, if qualified, as a foster parent. If such home is found to be unqualified for approval or certification, the local commissioner shall report such fact to the court forthwith so that the court may make a placement determination that is in the best interests of the child. II. An order placing a child directly with a relative or other suitable person pursuant to this part may not be granted unless the relative or other suitable person consents to the jurisdiction of the court. The court may place the person with whom the child has been directly placed under supervision of a child protective agency, social services official or duly authorized agency during the pendency of the proceeding. The court also may issue an order of protection under Section 1056 of this part. An order of supervision issued pursuant to this subdivision shall set forth the terms and conditions that the relative or suitable person must meet and the actions that the child protective agency, social services official or duly authorized agency must take to exercise such supervision. I. The court shall state on the record its findings supporting the placement in any order of placement made under this section. The order of placement shall include, but not be limited to, a. A description of the visitation plan. B. A direction that the respondent or respondents shall be notified of the planning conference or conferences to be held pursuant to Subdivision 3 of Section 409E of the Social Services Law, of their right to attend the conference, and of their right to have counsel or another representative or companion with them. C. A date certain for the permanency hearing, which may be the previously scheduled date certain, but in no event more than 8 months from the date of removal of the child from his or her home. Provided, however, that if there is a sibling or half-sibling of the child who was previously removed from the home pursuant to this article, the date certain for the permanency hearing shall be the date certain previously scheduled for the sibling or half-sibling of the child who was the first child removed from the home. Where such sibling or half-sibling has a permanency hearing date certain scheduled within the next 8 months, but in no event later than 8 months from the date of removal of the child from his or her home. D. A notice that if the child remains in foster care for 15 of the most recent 22 months, the agency may be required by law to file a petition to terminate parental rights. A copy of the court's order and the service plan shall be given to the respondent. And E. Where the permanency goal is returned to the parent and it is anticipated that the child may be finally discharged to his or her parent before the next scheduled permanency hearing, the court may provide the local social services district with authority to finally discharge the child to the parent without further court hearing, provided that 10 days prior written notice is served upon the court and child's attorney. If the court on its own motion or the child's attorney on motion to the court does not request the matter to be brought for review before final discharge, no further permanency hearings will be required. The local social services district may also discharge the child on a trial basis to the parent unless the court has prohibited such trial discharge or unless the court has conditioned such trial discharge on another event. For the purposes of this section, trial discharge shall mean that the child is physically returned to the parent while the child remains in the care and custody of the local social services district. Permanency hearings shall continue to be held for any child who has returned to his or her parents on a trial discharge. where the permanency goal for a child aging out of foster care is another planned permanent living arrangement that includes a significant connection to an adult willing to be a permanency resource for the child. The local social services district may also discharge the child on a trial basis to the planned permanent living arrangements, unless the court has prohibited or otherwise conditioned such a trial discharge. Trial discharge for a child aging out of foster care shall mean that a child is physically discharged but the local social services district retains care and custody and guardianship of the child, and there remains a date certain for the scheduled permanency hearing. Children placed under this section shall be placed until the court completes the initial permanency hearing scheduled pursuant to Article 10A of this Act. Should the court determine pursuant to Article 10A of this Act that placement shall be extended beyond completion of the scheduled permanency hearing, such extended placement and any such successive extensions of placement shall expire at the completion of the next scheduled permanency hearing, unless the court shall determine, pursuant to Article 10A of this Act, to continue to extend such placement. And B sep AMD cannot be together. B, where the permanency goal is returned to the parent and it is anticipated that the child may be finally discharged to his or her parent before the next scheduled permanency hearing, the court may provide the local social services district with authority to finally discharge the child to the parent without further court hearing, provided that 10 days prior written notice is served upon the court and the attorney for the child. If the court on its own motion or the attorney for the child on motion to the court does not request the matter to be brought for review before final discharge, no further permanency hearings will be required. The local social services district may also discharge the child on a trial basis to the parent unless the court has prohibited such trial discharge or unless the court has conditioned such trial discharge on another event. For the purposes of this section, trial discharge shall mean that the child is physically returned to the parent while the child remains in the care and custody of the local social services district. Permanency hearings shall continue to be held for any child who has returned to his or her parents on a trial discharge, where the permanency goal for a youth aging out of foster care is another planned permanent living arrangement that includes a significant connection to an adult willing to be a permanency resource for the youth. The local social services district may also discharge the youth on a trial basis to the planned permanent living arrangements, unless the court has prohibited or otherwise conditioned such a trial discharge. Trial discharge for a youth aging out of foster care shall mean that a youth is physically discharged but the local social services district retains care and custody and guardianship of the youth, and there remains a date certain for the scheduled permanency hearing. Trial discharge for a youth aging out of foster care may be extended at each scheduled permanency hearing, until the child reaches the age of 21, if a child over the age of 18 consents to such extension. Prior to finally discharging a youth aging out of foster care to another planned permanent living arrangement, the local social services official shall give the youth notice of the right to apply to re-enter foster care within the earlier of 24 months of the final discharge or the youth's 21st birthday in accordance with Article 10B of this Act. Such notice shall also advise the youth that re-entry into foster care will only be available where the former foster care youth has no reasonable alternative to foster care and consents to enrollment in and attendance at an appropriate educational or vocational program in accordance with paragraph 2 of subdivision of section 1091 of this Act. Children placed under this section shall be placed until the court completes the initial permanency hearing scheduled pursuant to Article 10A of this Act. Should the court determine pursuant to Article 10A of this Act that placement shall be extended beyond completion of the scheduled permanency hearing, such extended placement and any such successive extensions of placement shall expire at the completion of the next scheduled permanency hearing, unless the court shall determine, pursuant to Article 10A of this Act, to continue to extend such placement. NB sep AMD cannot be put together. II, upon placing a child under the age of 1, who has been abandoned, with a local commissioner of social services, the court shall, where either of the parents do not appear after due notice, include in its order of disposition pursuant to section 1052 of this part, a direction that such commissioner shall promptly commence a diligent search to locate the child's non-appearing parent or parents or other known relatives who are legally responsible for the child, and to commence a proceeding to commit the guardianship and custody of such child to an authorized agency pursuant to section 384B of the Social Services Services Law, 6 months from the date that care and custody of the child was transferred to the Commissioner, unless there has been communication and visitation between such child and such parent or parents or other known relatives or persons legally responsible for the child. In addition to such diligent search, the local Commissioner of Social Services shall provide written notice to the child's parent or parents or other known relatives or persons legally responsible as provided for in this paragraph. Such notice shall be served upon such parent or parents or other known relatives or persons legally responsible in the manner required for service of process pursuant to Section 617 of this Act. Information regarding such diligent search, including, but not limited to, the name, last known address, social security number, employer's address and any other identifying information to the extent known regarding the non-appearing parent, shall be recorded in the Uniform Case Record maintained pursuant to Section 409F of the Social Services Law. III. Notice as required by paragraph II of this subdivision shall state, a. That the local Commissioner of Social Services shall initiate a proceeding to commit the guardianship and custody of the subject child to an authorized agency, and that such proceeding shall be commenced 6 months from the date the child was placed in the care and custody of such Commissioner, with such date to be specified in the notice. B. That there has been no visitation and communication between the parent and the child since the child has been placed with the local Commissioner of Social Services, and that if no such visitation and communication with the child occurs within 6 months of the date the child was placed with such Commissioner, the child will be deemed an abandoned child as defined in Section 384 B of the Social Services Law, and a proceeding will be commenced to commit the guardianship and custody of the subject child to an authorized agency. C. That it is the legal responsibility of the local Commissioner of Social Services to reunite and reconcile families whenever possible and to offer services and assistance for that purpose. D. The name, address and telephone number of the caseworker assigned to the subject child who can provide information, services and assistance with respect to reuniting the family. E. That it is the responsibility of the parent, relative or other person legally responsible for the child to visit and communicate with the child, and that such visitation and communication may avoid the necessity of initiating a petition for the transfer of custody and guardianship of the child. Such notice shall be printed in both Spanish and English and contain in conspicuous print and in plain language the information set forth in this paragraph. C. In addition to or in lieu of an order of placement made pursuant to subdivision B of this section, the court may make an order directing a child protective agency, social services official or other duly authorized agency to undertake diligent efforts to encourage and strengthen the parental relationship when it finds such efforts will not be detrimental to the best interests of the child. Such efforts shall include encouraging and facilitating visitation with the child by the parent or other person legally responsible for the child's care. Such order may include a specific plan of action for such agency or official, including, but not limited to, requirements that such agency or official assist the parent or other person responsible for the child's care in obtaining adequate housing, employment, counseling, medical care or psychiatric treatment. Such order shall also include encouraging and facilitating visitation with the child by the non-custodial parent and grandparents who have obtained orders pursuant to Part 8 of this article, and may include encouraging and facilitating visitation with the child by the child's siblings. The order may incorporate an order, if any, issued pursuant to subdivision C of Section 1027A or 1081 of this article, provided that such visitation or contact is in the best interests of the child and his or her siblings. For purposes of this section, siblings shall include half-siblings and those who would be deemed siblings or half-siblings but for the termination of parental rights of death of a parent. Nothing in this subdivision shall be deemed to limit the authority of the court to make an order pursuant to Section 255 of this Act. D. In addition to or in lieu of an order of placement made pursuant to subdivision B of this section, the court may make an order directing a social services official or other duly authorized agency to institute a proceeding to legally free the child for adoption, if the court finds reasonable cause to believe that grounds therefore exist. Upon a failure by such official or agency to institute such a proceeding within 90 days after entry of such order, the court shall permit the foster parent or parents in whose home the child resides to institute such a proceeding unless the social services official or other duly authorized agency caring for the child for good cause shown and upon due notice to all parties to the proceeding, has obtained a modification or extension of such order, or unless the court has reasonable cause to believe that such foster parent or parents would not obtain approval of their petition to adopt the children in a subsequent adoption proceeding. E. No placement may be made or continued under this section beyond the child's 18th birthday without his or her consent and in no event past his or her 21st birthday. However, a former foster care youth under the age of 21 who was previously discharged from foster care due to a failure to consent to continuation of placement may make a motion pursuant to Section 1091 of this Act to return to the custody of the local Commissioner of Social Services or other officer, board or department authorized to receive children as public charges. In such motion, the youth must consent to enrollment in and attendance at a vocational or educational program in accordance with paragraph 2 of subdivision of Section 1091 of this Act. F. If a child is placed in the custody of the local Commissioner of Social Services or other officer, board or department authorized to receive children as public charges, such person shall provide for such child as authorized by law, including, but not limited to Section 398 of the Social Services Law. G. If the parent or person legally responsible for the care of any such child or with whom such child resides receives public assistance and care, any portion of which is attributable to such child, a copy of the order of the court providing for the placement of such child from his or her home shall be furnished to the appropriate social services official, who shall reduce the public assistance and care furnished such parent or other person by the amount attributable to such child. Provided, however, that when the child service plan prepared pursuant to Section 409(e) of the Social Services Law includes a goal of discharge of the child to the parent or person legally responsible for the care of the child or other member of the household, such social services official shall not, to the extent that federal reimbursement is available therefore, reduce the portion attributable to such child which is intended to meet the cost of shelter and fuel for heating. H. Any order made under this section shall be suspended upon the entry of an order of disposition with respect to a child whose custody and guardianship have been committed pursuant to Section 384B of the Social Services Law, and shall expire upon the expiration of the time for appeal of such order or upon the final determination of any such appeal and any subsequent appeals authorized by law. Provided, however, that where custody and guardianship have been committed pursuant to Section 384B of the Social Services Law or where the child has been surrendered pursuant to Section 383C or 384 of the Social Services Law, the child shall nonetheless be deemed to continue in foster care until such time as an adoption or other alternative living arrangement is finalized. A permanency hearing or hearings regarding such child shall be conducted in accordance with Article 10A of this Act. Nothing in this subdivision shall cause such order of placement to be suspended or to expire with respect to any parent or other person whose consent is required for an adoption against whom an order of disposition committing guardianship and custody of the child has not been made. In making an order under this section, the court may direct a local Commissioner of Social Services to place the subject child together with minor siblings or half siblings who have been placed in the custody of the Commissioner, or to provide or arrange for regular visitation and other forms of communication between such child and siblings where the court finds that such placement or visitation and communication is in the child's best interests. Placement or regular visitation and communication with siblings or half-siblings shall be presumptively in the child's best interests unless such placement or visitation and communication would be contrary to the child's health, safety or welfare, or the lack of geographic proximity precludes or prevents visitation.